Good day, good afternoon, good morning, whenever it is. Hello, hope everybody's well. I will talk slowly for a couple of seconds so some people can join. Conjoin, that means they're twins, right? If they conjoin. Anyway, hope you're all well. Greetings to who I see out there would be, again, my most loyal follower. Really, I have to give compliments to my most loyal follower, Mr. StreamYard. Thank you for always being here. Splat, I love that. Renee, I'm looking to the side. Gator Boy, just changed the 1-1. Black Mongo 42. Tim Casey. Hello. And Mark. Hi, y'all. If somebody else comes on middle ground, if I see you, I'll call you out. Ricky, etc. Did I miss somebody? I did. I missed middle ground. No, I said middle ground. Scott, Barefoot, Lee, etc. Anyway, hope you're all doing well, and whoever else joins us. I'm just trying to keep this kind of as a continuing conversation where I kind of bring you up to date as to what I see going on. So you're on top of it. Now, before I start, I'll do a couple things, but before I start, again, we start bottom line. My interest is in seeing a real deal done so the company can trade, so the shareholders will get what they're entitled to. That's my goal. And everything that I'm doing is based on that goal. So that's kind of the underlying. So notwithstanding whatever I say, I still want a deal to be done. So whatever critiques I'm offering are done just to point out what's going on, so nobody's in the dark and everybody knows what's going on, and to encourage some kind of fair resolution for retail shareholders, because that's ultimately what we all want, is a fair resolution for retail shareholders. What goes on during the case, now I'm talking about GTII, by the way, and I haven't done our jokes yet, but I'll get there. What goes on doesn't really make a difference, because if ultimately GTII doesn't trade, then all this is kind of bullshit, right? Whatever happens in court, whatever happens with the receiver, et cetera, it's kind of bullshit because it doesn't make a difference to shareholders if it doesn't trade again. So that's our goal. At least that's my goal. And I'll talk about a little bit more today, and kind of a tweet that kind of concerned me. And that's why I kind of decided to do the live stream. And just to let you know, wow, this is the longest intro. I hear from all, many people, many have different interests. And I'm, let's say, on guard when I'm dealing with anybody. And even if I don't announce it, I'm concerned about their underlying motivation. And just, that's, to be honest, and I've been contacted by a ton of people, and some I believe more than others. So that's my preface. So I think I started the last live stream. I kind of did a different format, and that's going to be the format as we go forward in terms of the jokes. I'm going to do a total, and I said the last time, I'll repeat it a few times until it becomes commonplace. I'm going to do 6 jokes per live stream, 4 at the front and 2 on the back. And I call them jokes because they may not be jokes, but that might be a little presumptuous on my part. So I apologize if they're terrible. But anyway, yesterday the school called me and said that your son is telling lies. I replied, tell that kid he's doing an amazing job, because I don't have any kids. My brother always lies. Now, of course, I don't have a brother, but just for the sake of this joke, I do. My brother always lies. It's terrible. Today, he finally admitted that he's a pathological liar. You know what? Yeah, he thinks I'm falling for that. What kind of machine never lies? A fax machine, of course. And what do you call a priest that always lies? A pathological friar. And we'll do the rest on the return. So pause. Now to the more serious stuff. So again, I put this on to make sure everybody's not in the dark, because in my view, most times in these situations, retail shareholders are in the dark, have no idea what's going on, make decisions based upon maybe incomplete information or lack of information. So that's my goal. So some of it you may not like, some of it you may like. Some people don't like it because I hear, because it may be touching on people's interests. But when I hear from people like that, I know that, or it makes me think about motivations and interest. Anyway, so the thing that kind of caught my attention, and I think I talked about this, is fair compensation. We'll get to that, but I want to kind of see how we get to that. And I talked about fair compensation a little bit 3 weeks ago or 4 weeks ago when I talked about double billing. So this is kind of continuation of this, but I wanted to kind of reference a tweet and kind of go from there. So understanding, and I haven't heard anything to the contrary, is that there's ongoing negotiations between the receiver and his representatives and AIversity with regard to a potential transaction. I haven't heard of any other entity or any other potential transaction to date, so I don't know of anything else going on. And nobody has said to the contrary, other than a tweet that I saw, I think it was yesterday or the day before, from John Forster, and he basically said, and this is not verbatim, but basically said he had not heard that they're trying to do a deal, and he's not heard in the receiver for quite some time. Crickets. That's what he said. And it seemed like my interpretation of that was he was annoyed and growing very impatient. That was my my read on that, and that caused me concern because, as I kind of preface this, without a deal, this is bullshit. Nothing's going to happen if there's not a transaction that's consummated. Besides the audit, and again, we don't know about the audit because the audit still hasn't been done, and we don't know when it's going to be completed, and the receiver has not. And it might be today, by the way, but the receiver hasn't given us any kind of indication, and his counsel has been reluctant, I guess, to inquire. That's the best I will say. So we really don't know, and we know that an audit has to be done before we can move forward. So we're still waiting on that. But we'd all heard about a transaction going forward, and when Forster posted that tweet, that causes you concern. So if the receiver hasn't been in contact to Forster for some time, what does that suggest, and why is that, and what is going on? We haven't heard any news to the contrary. The receiver certainly hasn't updated us about that. Is that incorrect? Is what Mr. Forster is saying not correct? The receiver or his counsel hasn't commented on that. I don't see why they don't comment on that. Seemingly could. But if a real deal does not go through, then we're just kind of wasting our time here. So the fact that the receiver, if in fact true, is not communicating with AIversity, then what are we doing here? Obviously, for this to go forward, it has to be a legitimate deal. If they're not communicating with AIversity, are they communicating with someone else? And who would that? And again, I don't know. So I'm just asking questions. Are they communicating with somebody else that they haven't disclosed? Is it a real arm's length transaction? Or is there any, is this a real deal? Are there any conflicts? Who are they, etc.? I don't know if that's going on in the background, and that's why there hasn't been communication with the Forster Group. If in fact that's true, there hasn't been communication with the Forster Group. And again, I'm not involved in those direct communications, so I wouldn't know. But the fact, again, that of the tweet suggesting that there hadn't been communication caused me concern and makes me wonder what's going on. And that's where this started. And then I went on. So I don't know what's going on as to that. And I as of this moment, I don't know what's in the head of the receiver as to the transaction with AIversity. Now, I believe, and I'll get into this in a little detail, my speculation, and this is pure speculation, is that perhaps in negotiations, what I'm going to talk about was discussed, and maybe there was some interaction about compensation, and perhaps that interaction was not well taken by the receiver. But that's just my speculation. I'll go into it in a little more detail when I get down below. So that's a problem. That's kind of outside of the issue of compensation. Why, isn't the receiver supposed to be communicating? Isn't that part of his job? What does he do? What does the receiver do? By the way, I'm not suggesting to get rid of the receiver. I'm just kind of calling out because I really don't know what the receiver is doing. Nothing in the reports gives me any indication what he's specifically doing. I know what his counsel's doing, again, because the counsel told me they had drafted one of the reports. So I know what the counsel's doing. And we got charged for that, of course, even though the receiver is yet to provide the invoices. So this is talking about like how he's conducting himself. It has nothing to do with how it goes as to the defendants, for example, because the last thing I want to do is the defendants to come forward and say they didn't get a fair shake because of the receiver, blah blah blah. I would say beyond everything, they've gotten an extremely fair shake to this point in time and have no reason to argue about what the receiver has done in any respect. They've gotten more than fair process to this point in time. So whatever statements I make are not with regard to that the defendants have some now ground to challenge the actions of the receiver. I think it's bullshit. That part's bullshit. What I'm talking about is what's going on as to the business aspects of the transaction. And that's unclear. And so that leads me to, so I'll leave that topic as is. And I'm going to move on to the next topic is kind of I raised the topic about double billing on the last, about 3 or 4 weeks ago, as I indicated. And the issue was, what is the receiver getting paid for? The receiver gets, and I'm going to read it from the receivership order, but the receiver gets 10% of whatever cash he brings in and 10% of the stock that he brings in. That's what the order says, and I'll read it specifically from the order. And so to this point in time, and these are rough numbers, so they're not exact, so don't take them as exact. But my understanding to this point, and let me back it up. So the receiver gets paid that, but what is the receiver supposed to do? The receiver is supposed to conduct the receivership, report to the people, etc. So for that, and I don't know what he's done because I know that the counsel has prepared the report. So again, I don't know what the receiver has physically done to earn his fee, but that's a separate issue. But to this point in time, I believe my calculation is the receivers received approximately $100,000 and 1.5 million shares. I don't believe he's sold those shares because I don't think that would be proper, and I don't think he could. But that's my assumption, and I don't know that for a fact. It would certainly be, I would think, improper, and this is just my opinion, for whatever it's worth, which is not a lot. But I would find it improper if he sold any of those shares that he got, the 1.5 million. And that's just an approximate number. And what is he doing to get paid? I don't know. But that's what he's been paid to date. And the issue would be, or one issue would be, is when can he dispose of those shares? Because I don't know. If he disposes them day one after it's tradable, is that insider trading? I mean, because he would be an insider. Is he able to trade them? Is he able to trade them right away? If he trades them right away, will then the company be shorted? Will he be able to trade it before other investors trade it? Would he trade it? Would he retain it? I don't see why he would retain it. I would think he'd want to make his money and get out, to be honest. My impression is I don't think he has any particular connection to GTII or its business. So how he disposes of those shares, I think, has not been determined. And I don't think it's referenced in the order, and we'll have to discuss that. But it may impact everybody else, because what happens if he trades his 1.5 million shares and people know that he's going to sell those shares? Are we going to have a bunch of other shorters come in to take advantage of that sale, and they're going to short the stock and basically dump it down to nothing? That's why when he could trade those shares is also important. But that's the compensation he's received today. But what can he receive? And I'm going to look at the order. So the order, this was the receivership order. And the way it was is counsel for plaintiffs group, and I was part of that group, filed a motion to appoint him as a receiver. I certainly didn't select him, but that's whoever did. Somebody selected him, placed him as the designee by the plaintiff's attorneys. And they did a nice job in filing a motion, creating the need to have a receiver appointed or somebody to take over the company. Paul Strickland was appointed. Now, when I was looking through the order is dated, just so you know, is September 18th, 2025. So he's been in place almost 1 year exactly. And what caught my attention before I go on in terms of how his compensation is spelled out, I had it here. I don't see it now, but his compensation. Yeah, it's interesting. I don't see it for whatever reason. But one thing that caught my attention was that paragraph 21, page 7 of the order, and this is September 18th of 2025. It says the court, with the incorrect spelling, the court notes that Mr. Strickland is ready and prepared to take immediate corrective action with respect to GTII's delinquent OTC and SEC filings. So that's a year ago. And as we haven't even finished the audit. So I don't quite get, compliance. Has he complied with that? And last but not least here's the compensation. So one, I don't think shareholders had any opportunity to participate in the selection process or the compensation process. Now, I do remember that the compensation was odd because normally what a receiver would do would charge an hourly fee. And this is not how it was set up. And at the time, and I'll read you the paragraph. At the time, what had happened is we had discovered, I think, because Nobari had canceled like 35 million out of 65 million shares that the shareholders had issued to themselves. That the management had issued to themselves, like in a January date. And Rabari, who came in, canceled like 35 million shares. So what we were thinking about at that time, since there was 65 million of those, that if they were successful, that we're talking about 30 million shares that were, let's say, of dubious nature. And we didn't know about anything else. So besides the fact that we didn't participate in the selection process or in drafting, specifically these documents, or coming up with the formula, the number that would have been in mind of kind of those bad shares was 30 million shares. So now I'm going to read you the compensation. That the receiver is hereby approved and authorized to be compensated for the services he renders on behalf of the receivership of state, subject to further application and order of the court. I'm going to stop for a second. Yeah, and so that means that the receiver has to apply to the court, and the court has to say yes. But to this point in time, I would say the court has been very willing to grant any type of fee request, whether it be by the receiver or legal fees, etc. So I'm going to go back just a few seconds. Subject to further application and order of the court in the amount equal to 10% of the value of all receivership assets other than GTI stock and securities recovered for the receivership estate by the receiver for the GTI to be paid out of the funds of the receivership estate plus 10% of all GTI stock and securities recovered for the receivership estate by the receiver. Okay? So when you look at that, and after the receiver got involved, then it became, or at least in the reports, and I don't remember which report, but it was certainly after his appointment, it appeared that he claimed, and I don't think it was the first or second, but I could be wrong, could be the second, could be the third, but he claimed then, and I'm approximating, there were about 180 million disputed shares. And I think I did a live stream where I literally went through each of the categories, the names, and the amount, and there were about slightly under 180 million shares. So we thought at most, I'm speaking for myself, at most there was 30 million disputed shares. But according to the receiver, there's 180 million disputed shares. So the difference is, if the receiver was able to cancel all those 30 million shares, he would get 10% of that, which would be 3 million. The way he's set it up, and these were not known, again, these were not known to shareholders or to anybody, as far as I know. He claims it's 180 million. He would then get 18 million shares. So let's think about that. So just think about it conceptually. Let's assume he's able to bring in all 180 million shares. He and outstanding with those disputed shares, I think, let's say there's approximately 450 million shares. I'm just approximating. And let's say he brings back the 180, he cancels 162 of those, 162 million of those, and he keeps 18. So that would reduce the share count from 450 to about 290. I'm just thinking out loud. And he would have his 18 million shares plus the 1.5 million shares he already has, which were, because of the cancellation now, he would have 20 million shares out of an outstanding 290. So he would likely be amongst the largest shareholders in the company. And that would be on top of that, that would be with having to pay his counsel to actually undertake those actions. So under Nevada law, and I'm no Nevada lawyer, but I kind of knew that was the standard. But, and this applies, what I'm referring to is a section on private companies, but I understand and again, I'm not a Nevada lawyer, so take it for whatever it's worth. My understanding is that under Nevada common law, and it's generally the understanding that, and I'm going to read kind of from the section. So this is for private companies, not public companies, but the same idea is going to apply. Per Nevada Code Title 7, Chapter 78, NRS 78.705, when it's talking about compensation costs and expenses of the receiver before distribution of the assets of an insolvent corporation. I'm just reading that from this one. Among the creditors or stockholders, the district court shall allow a reasonable compensation to the receiver for his or her services and costs and expenses of the administration of the trust. And the general standard, I think the overriding standard is it has to be reasonable compensation. So the question is 18 million shares, 20 million ownership, is that reasonable for what the receiver did? And is that ownership reasonable? Should the receiver become rich out of this deal? And the flip side of this is, can a deal be done if the receiver is going to end up being the largest stockholder? Is somebody going to be willing to do a deal if they have like some guy who owns 10% of the company to start off with? I would think that would be a real disincentive. I don't know, but I think that would be a real disincentive. So if in fact a deal is not done with AI-versity, and that turns out to be the reason, I would wonder and be suspect of any other transaction that occurred that somehow there was some hanky-panky going on with the shares. and I don't know that for a fact. I'm not aware of any deal other than the potential AIversity deal. But if this compensation issue ends up being the determining factor for killing a deal, I'd be surprised if a legitimate deal could be done. That's the way I see it. And I don't think that if the court would have known, and maybe they would have, but if the court would have known that they could get a significant ownership in the company, then how could that be reasonable? Now, on top of that, let's say they get 20 million shares. When can they sell those shares? Could they sell them day? I asked the same question about the 1.5 million. Could they sell them day one? If someone thinks they're going to sell them day one, won't that company be shorted to hell? Won't other shareholders be impacted? The ones who want to buy, a lot of shareholders are all excited. If this thing trades, they're probably going to buy, not sell. I'm speculating because I don't know what's going to happen, obviously, and I'm not making any recommendations. But if the receiver has some gargantuan sum of shares and wants to get his money out, and if he had if he had 20 million shares and if it was worth, I don't know what it's worth today, but let's say it's worth 10 cents, that's $2 million. That's not, chump change. Would that kind of encourage the shorting of the stock? Could he trade it earlier than everybody else? Would everybody else who was stuck then get basically screwed by that? And the order doesn't deal with how his shares can be terminated, sold, nothing. I didn't say anything in there about how he can dispose of them, what restrictions are there. Again, can he even trade them because they would be, he's an insider. So can he trade them? I don't know. But all that causes me concern. One, because it makes me wonder whether a real deal will be done if he's going to demand that. And two, if a deal comes along other than what he said he wanted to do, can we really trust that? And, as an alternative, I thought about that. So how would I do it if I were, based upon the fact that we really didn't understand that and it wasn't known? How could the receiver be compensated for the shares without being so dilutive and unfair to existing shareholders? And kind of what I thought, and the formula I thought was, how about he gets compensated monetarily for the number of shares he brings in? And I guess he's cited 180 million shares. So I just made up this formula, it just, you could take it or leave it, whatever. But I said, as opposed to the shares, he should get some kind of monetary compensation for bringing in the shares. And he's got, I'm not going to argue about the 1.5 million shares he already has, or approximate number that he has, other than how he's able to distribute them. But as to the 180 million shares, and let's just presume that he's able, and through counsel, although we have to pay for counsel, of course. And by the way, when I say that, I'm not disparaging counsel. Counsel for the receiver, I think they've done a competent job, notwithstanding the fact that I've disagreed with a lot of their strategy and how they've done it. I think in terms of their paperwork, they've done a competent job. Again, I would have done things differently, and I still would do things differently, but that, and I have no, I'm not accusing them of any improper practices, the Receivers Council. I just think their job and their allegiance is different. Their job and allegiance is to the receiver. Their job is to do tasks and get paid for the tasks. If they do tasks competently and get paid for those tasks, and GTII went bankrupt, I think they would sleep fine. That's my view. So, their interests could be divergent from shareholder interests at time, and that doesn't say anything badly about them. It just, that's a business, and shareholders' position is different. That's why, I've been watching them very carefully because their interests are different, I see, than shareholders. So instead of the issue about the 180 million shares and him getting 18 and then having 20 million of a float of maybe 290 or less million shares, and then being one of the largest shareholders and perhaps killing other deals, what I suggest is some kind of monetary compensation. So he's already made money and has shares, How about on top of that, on the 180 million shares, the first 60 million shares that he brings in, he gets a penny per share. That'd be 60,000 bucks. The next 30 million shares, he'd get 2 cents. That would be another 60,000 bucks. The next 30 million shares, he'd get it 3 cents a share. That would be 90,000 bucks. The next 30 million shares, he'd get 5 cents a share. That would be 150,000 bucks. And the last 30 million shares, he'd get 15 cents a share, and that would be 450,000 bucks. So that would mean, in my formula, and it's not my money, so I'm just throwing it out as a means of suggesting a different way of perhaps approaching this issue. He would have made approximately, and I don't know, it's on top of there may be other monies he brings in, and if he brings in other monies, he'll get 10% of that too. So that's in addition to that. So he's already made 100 grand, approximately 1.5 million shares. According to my formula, if he brought in all 180 million shares, he'd make an additional $800,000. Now that would be $1 million for a receiver. That is a windfall. I still think that would be excessive. That would probably be excessive compensation, but that's just another means of resolving the share issue that I think can be an impediment to getting this done. And that's notwithstanding kind of what I said about the double billing. What is the receiver getting paid for when his counsel is doing the work and getting paid also? That's just another question I have on top of that. So this again has nothing to do with the defendants. Doesn't excuse them in any way. In fact, again, to this point in time, they've gotten more than a fair deal. And whatever I'm talking about is unrelated to the treatment of defendants. So to the extent that they try to utilize that and throw shots at the receiver because they've been mistreated, I think that's nonsense. Just going to reiterate that. But how the business transaction is proceeding and what the compensation of the receiver should be and whether it's fair, I think those are all issues that need to be, stay on top of. And I think something has to be done, or some formula has to be suggested to deal with the shares, when they can be sold, can they be front run? Can they be sold? Is he an insider? All those issues, and along with the overall issue about fair compensation. Now, of course, I don't want that to stop any deal, nor should it be used to stop any deal. To the extent there's any opposition to compensation, that does not excuse the receiver from doing his job, ultimately. And ultimately, we want a deal to be done, the audit to be completed, this thing to trade, and for us to be able to trade it fairly and not to compete with the receiver and whoever else. So I'm going to leave it at that. That was my issue, the question of the distribution. If he brought in 180 million shares, how is that going to be treated? What are we going to do? What has he done? And again, the first part dealt with the issue about that Forster said that, it's crickets. So how do we reconcile what's going on when somebody who's supposed to be involved in the deal hasn't heard from the receiver or says he hasn't? Either that's true or not true. Either way, it's problematic, right? It's if it's true, it's problematic. If it's not true, it's problematic. So that caused me real concern, and I think we need more clarity. And that's the thing we don't. At this point in time, I've bitched about this for quite some time, and I understand some of the reasons for it. But there's a lot of ways that they could provide more clarity as to the status of things. And I wish they pushed the auditor for some determinative date. What is it? Just open? If it takes 19 years for the auditor to complete the transaction, is that okay? Is there a day? Is there a date? I don't understand the fear about not contacting the auditor just to get an update in time or to put a deadline in. That doesn't seem to work in the best interest of shareholders, that you're just kind of leaving it unhinged. I know I was told that the concern was that, that the auditors would react oddly, or they wouldn't accept it or something. It didn't make a lot of sense to me. But this is we have had 3 auditors, one that was shut down, one that the receiver said basically breached his fiduciary duty to GTII. I think that's basically what the receiver said in the report. And if you recall, I also bitched why the receiver, after saying that, didn't go after that particular entity, because maybe if they had gone after that entity when they claimed they kind of breached it, they would have completed an audit, or an audit could have been completed, or they could have used the litigation to expedite that process. But they chose not to. Again, I don't know why. Just like they haven't gone after Justine Reichman with an independent action, or Liz Penance against her place, which I disagree with, of course, in the receiver. I don't know why, but it is what it is. That's where it is. So today we want more information. We want more insight about the ongoing transaction, and we want more insight as to how the compensation of the receiver is going to work. And we also want the receiver to realize that he has a fiduciary obligation to complete his duties, and that he reports to the court, and that I talk about it, but there's tons of people that are watching what he's doing, and a lot of people that are frustrated. And it would be nice to, and part of that is, again, just a communication issue, a lack of communication, and that's where we are. So I'm going to leave it as is. When I have more information, I will let you know. I may do a stream, a space call. I'll let you know if that's the case. But I was thinking about doing that. I don't want to do too much to kind of, impede any progress. I just kind of want to put it out there so people could think about it. And, I raised it with the double billing in the past, and this is just for my further thought process about these shares and about the issues that arise about that. So I'm going to take a quick drink. Oh, that scotch is good. So just quickly again, summarize. We talked about Forster's tweet, talked about the double billing, or I call it double billing. Who's doing the work and who's getting paid. That's what I'm saying. I'm not saying double billing like in The Firm, the movie The Firm. I'm just saying that what is the receiver getting paid for when I thought he was supposed to report, et cetera, and his counsel's reporting, and they're charging substantial sums, and he hasn't produced the invoices that I've told him he could have redacted, but he hasn't produced the invoices, amongst other things. So I don't know that. So that's double billing. And then I talked about the share count and what problems that creates and how it might impede a transaction from being completed. And that if another transaction suddenly comes around, that we should be skeptical of any such thing. And I gave a different formula for resolving that in monetary terms, although it's not my money. And finally, that the receiver, whatever the receiver has done to this point in time, it's provided more than fair process to the defendants, and any complaint by them about the receiver is nonsense, in my opinion. So that's the summary. Now I'm going to go back to the final 2 jokes. We're going back to the final 2. And thanks for hanging out, by the way. What do you call it when lemons and limes lie? You call that pulp fiction. And last but not least, I'm sure you guys do this too, but I was walking through the cemetery last week, and I saw this epitaph on a headstone, which read, "Here lies an honest man and a politician." I exclaimed, I shrieked, You buried two guys in one plot? Hope you all have a great day. Be well, stay on top of this stuff, and stay informed. And hopefully we will get a deal closed and we will be able to trade again. Anyway,